Right from the jump, we're hearing the defiant tone. This guy thinks court orders are just suggestions. Oh, buddy, not a smart opening strategy.
I don't hook up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit.
If he thinks we can't do something, you're going to look at this judge and think, I can't do something, young man. You're going to learn a court calls the case of the people versus Marissy Hanky.
I'm letting it happen, Your Honor.
Good afternoon, Your Honor. Attorney Kevin Hassan, except on.
All right, sure much.
They're probably suspended due to allegations that he cut off his tether contact complaint. Following that particular bonding, client not contacted a complaint period. Also instructed my client, if allowed to keep back on bond, ask for to hopefully reinstate the original bond.
Notice how the defense is painting him as someone who now understands court orders? That's lawyer code for my client messed up badly, but maybe the judge won't hold it against him.
Tether, with no judge, he has no prior felony whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the plaintiff subsequent. Now, I just found out today, transcripts, boxes, so the language that was used in the conversation, I don't have phone conversations myself, but I will admit that it seems that my client had contacted the plaintiff. And so I say this, Judge, and again, I know it seems like my client is kind of throwing up his little fingers before.
Oh, yeah. Yes.
But Judge, I stated this young man, I think he understands now that the court orders are serious. Court orders him to do something it means. So Judge, I'm just asking, I guess, for some leniency to trust that Mr. Hanky will comply. He had a $75,000 cashier post to the bond. The only thing I can ensure is that if the court would give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So Judge, I am asking the court to reinstate his bond. And if the court is unwilling to do so, I'll at least ask that his phone privileges be allowed back on to at least contact family. Does he's never had any contact with the family, his children. He hasn't been able to contact his dad, irritate the court. So at the very least, the restriction is phone privileges to contact.
All right, Bill, before I hear from the people, counsel, let me just say, you came in here the first time, and well, let me start with this. Where's our tether?
I understand, Judge. I thought community correction still had it. I thought
He cut the tether off. We haven't seen it. And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back. Then,
Here it is, the bombshell. Cutting off a tether isn't just breaking a rule. It's like breaking the court's trust in the loudest, most reckless way possible.
you know, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your bond gets revoked. You get put in jail because of something that you've done, and then you still go about violating the court's order. I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. The court's asked him to do. Just send it.
Your Honor, I will say on a motion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked to different pins he's using. Then to the other number, we have 23 calls that were made since his privileges were revoked to different pins. And it's one of these.
And there's a smoking gun, jail calls. 45 calls to the same number, using other inmates' pins. That's not accidental contact. That's a full-blown catch-me-if-you-can mission.
Calls as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world stopping me from you. I don't hook up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you until I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing. And then, why stop now if they already?" So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim with other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel? I mean, counsel, does your client want me to just request of the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number?
Oof. That line from the judge, "You're not that big, not that bad," is basically a legal mic drop. When a judge says that, it's game over for mercy points.
If he thinks we can't do something, and if you're particularly, you're going to look at this judge and think, I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is kids say, mess around and find out. I guess that's not the quote, but it's close. I did pretty good. I said it okay. Right now. All right.
So just, if I may, just briefly, my client would like.
Go ahead.
I want to apologize. I don't think I'm being mad. Get pregnant by my child. I can't say that I'm not in here looking. I obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being mad. I don't want to be here. Really don't. Truly. Can't please show mercy. Please.
I have no problem showing mercy to those that.
Final verdict. Bond still revoked. The defense gambled on leniency. But this case is a perfect example of how repeated defiance kills your second chances in court.
Deserve it and ever. You have not. Motion for bond reduction or any change is denied. This bond will continue as revoked.
And for the record, I was also
Yes, sir. Is all discovery complete?
And I would ask if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge Perry.
And Your Honor, I did want to make it clear where I did contact the jail yesterday, and they have blocked both victims' new numbers and new numbers, so there should not be any more
More calls coming. All right. Thank you.
Thank you very much.
Thank you, Your Honor.